Mr. Kaminski.
Thank you, Mr. Chairman, for letting someone from your neighboring state of Maine have a moment to speak. I appreciate the privilege to do that. My legal work oftentimes brings me over to New Hampshire in terms of working with people who are doing affordable housing and community revitalization work, and I've done quite a bit of work in Keene, as well as Portsmouth, Belmont, and other places around the state. But this afternoon I am here to talk with you about H.R. 24. And I'm going to try very hard to keep my remarks brief. I may have information that is responsive to a lot of questions that some of the earlier speakers and representatives may have raised, and certainly I'll be open for any questions you might have at the end of my remarks. But I want to focus on three things primarily. First of all, process. Secondly, the expansion of executive power by this administration and the precedent it creates as the third thing. First of all, process. One of the earlier speakers this afternoon had a copy of Jefferson's manual and read from it for the committee. I am afraid that speaker may have left the committee with a misimpression about the text of Jefferson's manual, and I do want to address that. The earlier speaker read a part of that section, but not the entire section. And Jefferson's manual, section 603, does provide that impeachment can be commenced, and I'm going to quote, by charges transmitted from the legislature of a state. And that's why we're here today. And Mr. Chairman, I'd like to leave this copy with you so that it can be placed in the records of the committee.
No problem at all.
Let's focus on that and focus on the standards and the process that Jefferson's manual and the Constitution set out, and the role of a state legislature. The quote is, charges transmitted by the legislature of a state. It's not statements of fact absolutely proven. It is not ungrounded accusations. It is charges. There is no necessity for a state legislature to go through a painstaking fact-finding inquiry in order to bring forward charges. That's what the impeachment inquiry in the House of Representatives in Washington is about, and the process in the Senate is about when it tries the impeachment. The threshold question I submit to you is, are there serious issues that ought to be taken up by Congress? And our federal system gives each state legislature the ability to ask, are there things seriously going wrong in terms of impeachable offenses in the administration in Washington that should be looked into by the House of Representatives? Are there charges to be brought to have the House of Representatives look into it and go through their process? I submit to you that this committee has no authority to compel the Bush-Cheney administration to come forward with anything in response to your inquiry about whether there are charges. Again, that's for the House of Representatives in Washington. So I believe that is the standard that this committee ought to look at. I am here speaking in part on behalf of Maine Lawyers for Democracy. We're an organization of 80 Maine lawyers who support civil rights and civil liberties, and we have adopted a position calling on Congress to conduct an impeachment inquiry. We reach this on a nonpartisan basis. Many of the things that you've heard here this afternoon have been quite partisan and quite accusatory, but we come at it from the approach, what is there going on with respect to the Constitution? What is there going on with respect to executive power? And what we observe is that there is a continual expansion of executive power under the Bush-Cheney administration. A continual expansion to take the use of executive power to the point where it cannot be questioned. It cannot be questioned by Congress. It cannot be questioned by the courts. It cannot be questioned by the people. We look at things like the administration's use of the signing statements to announce what provisions of law the administration simply feels not bound to comply with. My primary example that I want to bring to you, although there are lots of them, is the administration signing statement with respect to Senator McCain's torture legislation. The Bush administration, President Bush, signed the bill, but issued a signing statement saying, I do not feel bound to comply with the provisions of this bill that outlaw torture because, in my judgment, they may conflict with my constitutional duties as Commander-in-Chief. Turning his back on Congress, there is no ability of Congress to veto a signing statement. To override a veto when the President issues a signing statement. There is no ability of Congress to say to the President, you've got that wrong. The President's word with respect to that kind of a signing statement becomes finality, not subject to challenge. We see that in many aspects of the use of executive power, not answerable to anyone. We see the administration refusing to honor subpoenas provided to members of the administration by Congress to allow Congress to conduct its oversight. We see the administration coming forward and conducting domestic surveillance and wiretaps without going to the court, as they were required to do by the FISA law, and having a program of domestic surveillance and wiretaps that was so unconstitutional that even John Ashcroft refused to approve it at one point. And we raise this as much as we can in a nonpartisan basis. And I would ask members of the committee to ponder a question that I pondered as well, which is, given this vast expansion of executive power that's gone on, how would we feel if that executive power was wielded by a Hillary Clinton or a Barack Obama or a John McCain? I would urge members of the committee to put yourself in the shoes of someone seeing a president of the opposition political party doing things that you thought were absolutely unacceptable and not being able to question them in Congress or the courts. And I'd ask you, is that the sort of nation that we want to leave to our children? I'm going to pause there, and I'm going to suggest that the precedent that would be set by allowing these actions to go unchallenged and this expansion of executive power to go unchallenged would set the stage for future administrations to do the same thing time and time and time again without challenge. Let me stop there. I'm open for questions from the committee.
Okay, thank you. That's quick, no questions.